This will be a bit more academic. I'm trying to make an observation and to see what I can do with this observation. I think that those of us that reflect on both international and domestic national criminal law can detect two opposing tendencies. In the past few decades, when it came to international criminal law, it has become more and more restrictively individualistic, meaning that those doctrines of group criminality that were certainly part of the Nuremberg Charter were not used since then and are certainly absent from all the charters that we have seen since, from the Rome Statute and from the charters of the specific courts. At the same time, we see a different tendency, an opposing tendency, in national criminal law that has become more and more group-oriented. And I will not go into this now, because this is a matter of domestic criminal law, but I will give just one example. 2 years after the Rome Statute, in the year 2000, the UN approved the Palermo Convention, which required all the states to prohibit, enact domestic laws prohibiting the active participation in a criminal organization. Now, this is a form of liability that was abolished in ICL post-Nuremberg. We saw it in Nuremberg, and then it was abolished. And this these opposing tendencies should be quite surprising if one takes into account the obvious fact that the perpetrators of international crimes are generally groups, and even very large groups, such as states, militias, and ethnic groups. And this has led some prominent writers, one of them was here yesterday, probably the most prominent of them, to conclude that ICL should be more group-oriented and wish for a more group-oriented jurisprudence in ICL. Now, what I try to do in this paper is understand why this hasn't happened, because it seems like an obvious conclusion, but it is obviously not being realized. And the question is there anything inherently individualistic about international as opposed to national criminal law? I endeavored to detect some distinctive features of international criminal law that make it so restrictively individualistic, and I employ 5 different concepts, namely selectivity, capacity, expressivity, symmetry, and legitimacy. I will go into each very shortly. Well, one point that I think is quite obvious is that while international crimes are committed by groups and so deserve group doctrines of criminality, the vast size of those groups hinder the possibility of using group criminality, because the groups are so large, if we talk about states, even if we talk about ethnic groups, that it is almost impossible, first of all, when it comes to the makeup of those groups, to discern those that are guilty from those who aren't, those who would be guilty under such group doctrines just by passive nationality, or even the victims, because usually the persecutors and the persecuted all come from the same group, which we have to now find and prosecute. Another problem is obviously, when concerned with the size of the groups, is that you can either opt for mass imprisonments, which is unrealistic, or alternatively go for mass impunity, which would be unjust and would undermine the whole, the whole project. And so, pragmatically, a middle path has been taken. It was taken at Nuremberg. It's been taken ever since in ICL, and that is selectivity. You choose some representatives of the groups to be indicted and punished. Now, I don't have much to say about that per se. I mean, obviously, there are some problems concerned with selectivity. It may be unfair in itself, but that seems obvious. The thing that I do want to say here is that even if you choose selectivity as your way of indicting or framing prosecutions in ICL, I think it would be better, even under those circumstances, to frame the indictments in terms of actions and not affiliations. And the reason is that any claims of selectivity would be much less strong when the defendant will ask, why should I be reprimanded for my deeds, or why should only I be reprimanded for my deeds, as opposed to why should I represent the group? I think the second of these questions is much harder to answer, and so indictments should be and generally are based on individualistic doctrines. Now, in comparison, if we look at group criminality on the national front, we can say that criminal organizations are generally much more cohesive. They are smaller by comparison, much smaller by comparison, and can be perceived as being and identified as being more purely aggressive. There isn't that disparity between the different types of members belonging to the groups. Generally speaking, all members of a criminal organization are criminals, and they all take part of the criminal activity. Now, a related point, which might be a little less obvious, but I think it's all part of the explanation, is that if we look at international criminal law and national criminal law's aims in using group criminality, we see that those aims are very different. For national criminal law, the main difficulty the law faces when it comes to group criminality or dealing with collective action is asserting the responsibility of the leaders for the conduct of their subordinates. And this is because the hierarchies of criminal organizations are much less bureaucratic than those of states and militias. Now, this makes a very appealing case for adopting group criminality doctrines, because you go after the big fish. And if you look at international criminal law, when it comes to the same type of problem, when it comes to locating the responsibility of military leaders, for example, we find that ICL has been very generous in its doctrines concerning command responsibility. But this sort of inventiveness and generality in doctrines has not been afforded when it comes to states and to the wish to find the responsibility of the riled up masses for implementing the crimes or perpetrating the crimes that were thought of higher up. Now, here we go into the problem of capacity. And obviously, when it comes to members of a state that implement the doctrine given from higher up, it's very hard to think of full capacity. Generally, you think of, especially if we follow Arendt in this respect, we talk about a curtailment of the faculties of knowledge, understanding, and control. And by appealing to individual responsibility in ICL, the law creates a forum for discussing responsibility, and in this forum, the level of by which the faculties of responsibility are curtailed can be assessed. Another point is expressivity, and here we should look at the time at which indictments are brought to the courts. National criminal law proceedings typically take place during the lifetime of the criminal organization. This means that the aims of criminal law are generally to demolish the organization, or to alleviate its threat. Whereas in ICL, proceedings generally take place after the aggressive regime has been dissolved or disarmed by means other than legal. And so, for example, if we just take a very famous illustration, when it comes, if the mafia is an ongoing risk, then it should be eliminated even by the crude means of holding Al Capone responsible for tax evasion. In ICL, we have much more place for expressive justice. Now, the political nature of ICL is obvious, and I don't want to go into that, but two related points are those of symmetry and legitimacy. Basing liability on group criminality or group responsibility gives the defendants grounds to refer to similar conduct by rival militaries, the existence of which is the inevitable consequence of the symmetries of warfare. And perhaps more remotely, the accused can allude to the past and to past conduct of the prosecuting country. This was used most famously by Klaus Barbie in his defense. He was referring to France's occupation of Algeria. This was not a successful defense, but it's obviously better for it not to be brought up at all. Now, another point is that in ICL, but not in national criminal law, international criminal law may be turned against the state that enacts or adopts it. It is experienced by the drafters as unsafe, and so is more restrictive than rules that the state has full control of and are used only against threats outwards. And lastly, and most prosaically probably, a reason for ICL's strictness may lay in ICL's utilitarian strive for legitimacy. There is much murkiness in ICL, and so wherever you can find some foothold, you step on it. And here, the foothold is the strict reliance on doctrines of individual justice. Thanks.